Welcome to Rebel Chaser. My name is Gail, and I've got 4 videos for you today. The first one is with Judge Villarreal. The second one is Judge McNally. The third one is Judge Dukes. And then the last one is again with Judge Villarreal. So I'll let you guys watch.
Vanessa Rodriguez, Alberto Rodriguez, Bernarda Rodriguez, Enrique Jesus Canet. Cause number 2018 FLI 2278C3. Court marks Mrs. Cotto present in person. Nathan Chu, are you present? Court marks Mr. Chu not present. Court marks Mr. Garcia present and participating by video conference. Good afternoon, Mr. Garcia.
Good afternoon, Judge.
Vanessa Rodriguez, Alberto Rodriguez, Bernarda Rodriguez, Enrique Canet. Is any party present?
Are in the back, Judge, so they're bringing them in, and they do need interpretation.
Yes, I'm present.
Are you Enrique Jesus Canet?
Yes, sir.
The
Yes, Your Honor. Sorry.
Present and participating by video conference. Your lawyer is Mr. Chu, Mr. Canet?
Yes.
All right. Mr. and Mrs. Rodriguez, I'm going to ask that you step in front of a microphone each. Pull the microphone as close to your mouth as possible. We'll begin Spanish language interpretation. Are you Alberto Rodriguez? Yes. Court marks you present in person. Are you Bernarda Rodriguez?
Sí.
Yes. Court marks you present in person. And the person to your left is your lawyer. Mrs. Cotto?
So on this particular case, Judge, I just texted Mr. Chu. He is in a jury trial in the 341st. He asked that if the court called the case, if a deputy could go and pick him up. But that's that I leave that to the court. He does have 2 co-counsels. I went down there. He's trying a case with Mr. Knotson and Mr. Davila. And so this case has been continued and continued. We appointed Mr. Garcia to assist us. I represent, and it has been my pleasure to represent Mr. and Mrs. Rodriguez. They are the maternal grandparents of Adelaide, who is 8 years old. Adelaide, since she was a baby, has lived with my clients and her mother, Vanessa Rodriguez. My clients were in charge of picking her up, taking her to school, feeding her, taking her to her extracurricular activities. They have a very strong bond with their granddaughter. Tragically, on February 14th of this year, Vanessa was, as you can imagine, Judge, this has not been a easy time, not only for Mr. and Mrs. Rodriguez, but also this 8-year-old child. There is an OAG order that had Mr. Canet and Ms. Rodriguez as joint managing conservators, with her having the exclusive right to determine the residence of the child. After Vanessa's funeral, Mr. Canet took it upon himself to go to the school, remove Adelaide from the school, and not till I filed the intervention, not till I begged opposing counsel for access to the child, were visits finally allowed last month. There's been several motions for continuances filed. I was hopeful, given the last 2 Rule 11s, because of the continuances that were filed, that there would be some type of breakthrough with regards to the presence of my clients in the life of this child, given that Adelaide had never slept over with Mr. Canet. His visits had been inconsistent at best. And at the last visit, we were happy because Mr. Canet had allowed my clients to keep Adelaide for a longer period of time, take her to school. And so I really thought a breakthrough had been done because of Mr. Garcia and because of his ad litem report. And so I was informed by Mr. Chu's staff today that he had filed the continuance. Obviously,
All right, so let me get some things on the record. I've been listening, but I've also been reviewing this case's procedural history. The court has ascertained that this setting has been continued twice, and then the court reviewed the motion for continuance, and the court sees that the continuance was filed yesterday. So the court's question was, well, when was this jury trial set? The court has reviewed the procedural history for that case, and it looks like the docket entry says, Honorable Judge Joe Maldonado Jr. on April 16, 2025, set the jury trial for May the 5th. So,
and obviously Mr. Garcia and I did not get notice of that motion till maybe 3:43 when it was filed yesterday, Judge. I had.
right. So this is what the court needs to do. Court is going to ask our Sergeant at Arms to advise Mr. Chu that the court is calling this case, and the court will call it within 5 minutes of you notifying him, and he needs to either come to court or send some information back with you about whether he intends to be present or not. All right, so stand by for the court to receive that information. Any questions as we reset or pause, Mr. Garcia?
No questions, Judge?
Mr. Schomburger?
No, in this case, Your Honor, we can file a notice of non-appearance. Obviously, grandparents have no duty to support, so this sounds like a grandparent possession access type case. So I don't think we need to be involved in this, Your Honor. If you want to excuse us, or we can file a notice of non-appearance.
You're excused on that basis. Thank you. Mr. Canet, stand by.
Yes, Your Honor.
Mr. Valadez, stand by. I'm going to call page 1, case 2, Vanessa Rodriguez, Alberto Rodriguez, Bernarda Rodriguez versus Enrique Jesus Canet, cause number 2018 FLI 2278C3. Mrs. Cotto is present in person. Mr. Chu is now present in person. Mr. Garcia is present by video conference. Mr. and Mrs. Rodriguez are present in person, and Mr. Canet is present by video conference.
Good afternoon, Judge Nathan Chu, present for Mr. Canet.
Good to see you, Mr. Chu. The court marks you present in person. All those persons are present. Mrs. Cotto, Mr. Chu, announcement.
So, Judge, I as I told the procedural history of this case to the court previously before the deputy went to get Mr. Chu, I understand he's in a jury trial. That has been verified. I wish I would have known before I was served yesterday. The issue really at this point, it looks like Mr. Canet has agreed that grandparents will have the minor child on the first, third, and fifth weekends of the month, Friday from school. So they'll be authorized to pick the child from school till Monday at school, as the guardian ad litem has recommended. So for purposes of what Mr. Chu is going through right now on the third floor, it's my understanding that that is the agreement, correct, Mr. Chu, to get you out of here?
Judge, mentally, I'm not ready for that. I filed the motion for continuance for good cause. I'd advised the court and counsel that I am in a jury trial. I've got a couple minutes before they recall me back.
Sure.
I've tried to reach an agreement so that we can, or move it to the next day, but I'm not sure what my client is agreeing to yet, Judge.
He can
That's the
ask him,
problem.
Judge, because we're here and these people have.
Mr.
been here since
Canet,
2 o'clock.
did you hear what Mrs. Cotto just told the court about a possible agreement for the first, third, and fifth weekends?
Yes, I did hear, but it didn't say Fridays on. They could go to school to pick her up. I said Friday at 6 p.m. When I get out of work, they can go pick her up at McDonald's, I'm sorry. And they can take her from there to Monday morning, so they can take her to school.
So the only difference is Friday at 6 and then the return Monday to school, pick up and drop off, pick up at McDonald's. Is that the agreement, Mrs. Cotto?
No, Judge, that's not the recommendation being given by the ad litem.
Let me hear from Mr. Garcia, please.
Your Honor, my understanding from Mr. Canet and from all counsel of record, currently right now, I believe Mr. Canet is still living in M.U.R.D.E.R.E.D with a possibility of moving into Laredo, Texas. I know he works a pretty solid schedule, I think about 40 hours a week. So what he had told me, Judge, is he wants a little bit of time to see his daughter when he gets out of work, because I guess he just wants to have that opportunity. I understand that. The way that I figure that it would be easier for all parties is to be picking up from school to make it easier for everyone, because I know it's going to be very difficult for Mr. Canet, who's still, working at that period of time when his daughter gets out of school. I would obviously, I'd recommend that during these types of visitations, I think it would be easier for all parties, even if it's just temporary, to make sure that there's no issues in regards to pick up and drop off, because it would have to be an adult over the age of 18 for Mr. Canet. I really don't think that he'd be able to
All right,
do
Mr.
it.
Canet, please unmute your device.
Yes.
Mr. Canet, this is going to be real simple, and the court's going to decide based on the very next thing that you tell the court. Do you understand me?
Uh-huh.
All right.
Yes.
Do you understand me?
Yes, I'm sorry.
All right. So give the court any good reason, cause, or basis. Let the court know why you would like these visits to start at 6 instead of immediately after school. What is that reason?
So I can just say goodbye to my kid, and that's it. Just to talk a little bit with her. And I don't know how to say it in English, but I can say it in Spanish.
If you prefer that, you may and will translate.
Yeah.
Go ahead.
Okay.
For me, it's better for 6 o'clock, because that way I can say goodbye to her. I can say I love you, and I can give her a hug. They're saying I live in Laredo, but I no longer live there.
I'm sorry about that,
Como
Judge.
quiera.
He had told me that, and I apologize, Mr. Canet. I didn't realize. I know you told me you were
All right,
already
let me hear
on
from
the process
Mr.
of moving.
Canet.
Sorry about that.
Go ahead, Mr. Canet.
When I
Hello,
talked to
hello?
Mr. Garcia, I explained that to him, and then I told him that on Sunday it was a day they were going to go, grandparents were going to go see the child, but I was going to go to Houston. And then when I came back, like I told Mr. Garcia, on Sunday when I came back, I got myself an apartment, and I brought all my stuff across and got it into the apartment that same day.
All right, unless there's an objection by any side, I'm just
This guy
gonna,
wanna
nobody's
pursue.
under oath. I'm gonna take everything that has been stated at least as true. Without knowing anything else, based on the facts as represented to the court, visitations are hereby approved as agreed to on the first, third, and fifth weekends of the month. Friday after school till Monday return to school. Mr. Canet will be allowed a video conference communication with his daughter at 6 p.m. The court finds that doing this is in the child's best interest. Mr. Canet, you've given the court a very good reason to grant your request. Wanting to interact with your daughter and say hello and goodbye to her is a good thing, but we're here for her best interest. But you can have daily video conference communication beginning Friday at 6 p.m. so you can get that interaction with her. Are there any objections to these orders, Mrs. Cotto?
No objection, Judge. We just have another request, Judge. It is Mother's Day weekend, and Mr. Chu's office have been conferring this afternoon with regards to what do we do about this weekend. The first weekend of the month was last week. Mr. Canet did not allow the visit to occur because there was nothing in writing.
Translation, please.
Because
Assuming all of that is true, so I can get Mr. Chu out of here as soon as possible. What is the request?
the request is that my clients pick up Adeline from school on Friday and return her back to Mr. Canet by 3 p.m. so that she can both spend some time with her maternal grandmother as well as her paternal grandmother.
Let me ask you both this, because you might be able to agree to this. Mrs. Cotto, Mr. Chu, if Ms. Rodriguez were alive and that weekend would not be a weekend for her to possess this child, what would her visitation be?
Judge, per the Texas Family Code, this would be her weekend.
Would that be the case, Mr. Chu?
That would be the case, Judge, but this is a grandparent access case,
Okay,
Judge. This
I
is,
fully understand. Court takes judicial notice of the 2025 calendar. Court's going to modify the agreement in the best interest of this child. May will be second and fourth weekends. June will be first, third, and fifth going forward until the final hearing on July the 10th. Any objections to those orders, Mrs. Cotto? Mr. Garcia?
No, Your Honor.
The last request is, Judge, that her school on Monday is having a Mother's Day activity from 8:30 to 9:30 because he's removed Mr. Rodriguez and Mrs. Rodriguez from having any access to being emergency contacts or anything else. They have to ask the court in writing. The school can authorize them.
But the only request then is for this one event.
For right now, to get Mr. Chu out, yes.
Any objection?
it was always something further, Judge, and it's also abridging on the rights of the father. I mean, we have no problem, but if, that's not what they're asking for.
That's what I'm for, just to be able to attend the school activity.
The only request before the court right now is one time
La única
for
petición ante la Corte
a
es una
Mother's
sola
Day
vez.
event on Monday. Any objection?
Para
It's
un
okay if there
evento de las
is.
Días
It's
Madres.
no.
Mr. Canet, do you have any objection to the grandparent showing up?
Señor,
No me
I'm
parece
having
nada.
problems with the cellular. So
Mr. Canet, Mr. and
Mande.
Mrs. Rodriguez are asking one time to go to your daughter's school on Monday for a Mother's Day event. Do you agree or do you disagree with that request?
De
I
grados
haven't received
escolares.
anything in writing. It says fourth and fifth grade. It doesn't say anything for second grade.
I have the authority to put it in writing and order that it happen. I can do that. But before I do, and I may or may not, but if that happens, my question is, do you agree or do you disagree with that request?
I'm in disagreement. I just wanted to make clear that what I said was that there on the paper, it just says it's fourth grade and fifth grade, not
I
second grade.
see, I see, Mr. Canet, but if, it's hypothetical, if there is an event, and assuming there is, let's assume for a second that there is, would you object to that request?
Sí.
Yes.
Tell the court why.
I would object because my partner, the stepmother, has been practicing the dances with her, and she calls her mommy and and that's why I would object.
Mr. Garcia, based on your knowledge of the parties and their history, what is your opinion?
Your Honor, to be quite frank, if there's going to be some type of participation, or if she's learning dances, then I would imagine that maybe the second graders will have at least some mother figure there with him to participate. Now, if that is the case, and Mr. Canet wants to send his, I guess, his significant other with his child to school, I would still have no objection to have the grandmother show up, not necessarily instead of the biological mother, but along with this woman who is basically now in the child's life, in order just for this particular event to help, for it to be in the best interest of the child.
This kind of crystallizes the issue for the court. Court will allow viewing and no participation on Monday. Viewing and not. Any objection, Mrs. Cotto?
No,
¿Alguna
Judge,
objeción?
and
Any objection, Mr. Chu?
Señora Patrón,
Any
¿alguna
objection,
objeción?
Mr. Garcia?
No, Your Honor.
Court finds that doing this, all of this is in the best interest of this child. These
La-
orders are due on
May 19th at noon by submission.
The only other request,
Mayo
Judge,
19.
is that we have a hearing for temporary orders because this is not, does not encompass all of the requests. This is just a Band-Aid to have something before the
Translation?
court. So maybe in June, if we can come back, Judge. Yeah, he won't allow
You,
that.
you have a final pretrial on June the 5th.
We can do that as a temporary orders date, Judge.
Temporary orders and final pretrial on that date as scheduled. All right. Anything else on this case?
At 2 p.m. 2
Yes.
p.m.
June the 5th. You already said for June the 5th at 2. For final pretrial, we'll just do a final pretrial and temporary orders. Anything that the parties need the court to hear.
That's all, Judge, so that Mr. Chu can.
Court appreciates your presence.
Señor Chu, la
And
corte
I
agradece su
apologize
presencia.
profusely. I just needed to get them some relief.
I certainly understand. Thank you, Mrs. Cotto. Thank you, Mr. Chu. Thank you, Mr. Garcia, Mr. and Mrs. Rodriguez, Mr. Canet. I wish you all the best. Good luck to all.
Thank you.
Sorry. Michael Street versus and Nikolai Santana Carnero versus Stephanie Allred. 2400596. Your name, ma'am?
Stephanie Allred.
All right. I'm going to sincerely hope that you have everything for me today, so I don't have to continue to adjourn this. Okay?
Yes.
All right. Your name's over here, folks. Your names?
Nicole Santana Carnero.
You got to get a lot louder and closer, folks. I got to hear you. Come on. We're across the country here.
Nicole Santana Carnero.
And Michael Street.
All right. So I told you to email plaintiffs the email that everything that was sent to them to the civil department. Do you guys have everything you need now? Please tell me yes. I'm going to lose my patience on this one. I don't like to lose my patience.
I emailed Lisa everything I received, and she said it's going to send it to you.
I can't even hear you. You got to get closer to the device, folks. I'm sorry. I don't. Have you provided everything I told you to provide?
Yes, there is a no contact order. I cannot contact them. So I have everything hard copy like you told me to bring.
Where is it?
Right in my hands. Right
Did you give it to somebody down the hall yet?
No, I came here first.
Go down and give it to Jennifer. She's going to come down and give you that to you. I want you to email this to these folks. I'm getting off the bench for 5 minutes and then I'm coming back and I'm asking you folks if you have everything you need. I'll be back in 5 minutes. Thank you. Recalling Street and Santana Carnero versus Allred, 2400596. Your name again?
Stephanie Allred.
Guest? Or Mr. Street, rather?
Yes, sir. Can you hear me good now?
Yeah, now state your name.
Michael Street.
Ma'am?
Santana Carnero.
Do you have everything you need?
I did not receive Jennifer's email. I don't know if it's back. I don't know what happened.
Jennifer, did you email everything over there?
Yes, Your Honor. I sent it to the Nicole@gmail.com.
NIKOLY@gmail.com.
NIKOLY, correct.
I have your last email here, Jennifer. I can answer to that.
Yeah, I sent it at 11:44.
What did you send, Jennifer?
Copy of the text.
We got it.
You got it?
The same things that we got last time. Her social security is blocked.
Well, I have a problem with the social security. I mean, I can do that later. I can worry about that later. Do you have everything else?
There is no social security card.
She doesn't have it, she said. She told him down there. What else?
She did not send the latest tax return, only the 2023, not the 2024.
Do you have the 24?
2024
Hang
was
on.
in that scan, Judge.
24 tax return was in the scan, right?
Yes, Your Honor.
Okay, so you're going to have that. You got to pay this. Okay? Where do you work now?
Next care, urgent care.
She can garnish your wages. They can garnish your wages. Next care, urgent care, which is where?
Where the corporate is based out of Arizona. I have 3 locations that I go to between Dundee, Ann Arbor, and Livonia.
You're gonna give me all those addresses right now. You got them all?
Yeah, I gave it to you last time. I know by her. And the time before then.
You gave them to me?
First, second, and this.
The addresses?
Absolutely. And I gave it to them on the record as well.
Is that right? Do you have her addresses for where she works at?
We have the address on the earnings statement, which is in Tampa, Arizona.
Did I give you the, hang on. Did you specifically spell out the addresses? Hang on. For next care, urgent care at the 3 locations you're referencing.
Yes, Your Honor.
You know them by heart?
Yes.
Good. Give me them again. Okay. Why are you not paying this debt at all?
I have, Your Honor, I was on medical from October until middle of January. My first check was February. I nearly died. I've had to have 3 blood transfusions, and I'm going through a hysterectomy as soon as I can afford to take time off work again.
Okay. I'm sorry about all that.
Yes.
Why don't you give me an amount you can pay? How much do you make an hour?
Well, I'm salaried.
How much do you make per week?
Right now I went exempt, so I get paid bi-weekly and I bring home 24.
I don't want to know that. What's your yearly salary?
71.
71,000?
Yes.
Why aren't you paying on the debt?
If you look at my last year tax return, this current year tax return, I only brought home 44 this year. I just started that job.
Do you have kids?
I do.
Any that are not adults?
Yes, I have 2 at home.
How old?
17 and 14.
Do you collect child support? How much can you pay per week or bi-weekly?
I mean, I'm check to check, whatever
I
tell me I have to pay, I have to pay. I mean, I literally have 80, I just got paid last week and I have 85 cents in my bank account. I'm trying to play catch up from everything. I've lost my daughter. I've lost my home.
She has no bank account before. She's just a compulsive liar. We are so frustrated, seriously.
Okay, let's stop. I don't want people calling people names.
It's so frustrating.
Never had a bank account till just now.
The probation officer, Ms. Wiles, keeps calling me, telling me that these people are calling routinely, like weekly.
All right. I don't want anybody casting aspersions. You owe them money.
Of course I do.
And you made it very difficult. I've never seen anybody here, just so you know, in 30 years and 4 months, I've never seen anybody here on creditor's exam on civil cases more than you. Imagine that.
It's the same
Hang on.
case.
Yeah, I know, because you didn't provide the information you were supposed to provide. No, you didn't. It took me multiple attempts.
Your Honor.
Ma'am? The debt is 5374. How much is she paid on this? Anything?
$150. She made 2 payments. She was in a payment. You asked her how much she could pay, and she was in a payment of $75 a month. She paid 2 months and stuff.
Jennifer, pull out an order for installment payments for me. I want you to prepare one.
Okay.
If you do this, if I set an installment payment, they cannot garnish wages. I want to be clear about that. If I do that, you guys cannot garnish wages so long as she's staying in accordance with the payment plan. And if she isn't staying in accordance with the payment plan, you're going to have to file a motion to set aside the installment payment order. Then you can garnish. So I'm going to set up a new one. She's going to pay on this. And it's ma'am, I just want you to understand one thing. I could get $1 million judgment. You can get $1 million judgment against somebody and never collect a single cent. I just want you to know that. I'm not trying to be a wise guy here. I'm not boasting about this. I'm sensitive to what you're going through, but I want you to understand Sometimes people are not collectible, okay? There's millions of them in this country. I'm trying to get you your money. I can't lock her up for not doing something unless she ignores orders of the court, and I'm going to set a reasonable amount. You're making $71,000. Talk to me about the rest of you. Jennifer, you're going to start to pay an installment or prepare an installment payment order,
I'm
please.
typing now. Yep, Judge.
Thank you. Now, I want you to tell me what your bills are. Where do you live?
I live in Boston,
Okay, where?
Mayfair Avenue.
How much in the apartment? You own the home?
No.
You rent the home?
I rent the home.
How much is it?
$14.50.
What else? What other bills?
My DTE is $476 right now.
Well, you're not paying $476 a month.
It's like $380.
I know, but this, okay.
I'm on a shut-off protection plan. That's my payment amount, $476.
Okay, what else do you have?
My cable in my home.
How much do you pay for cable?
$226.
Wow, that's a lot.
It's my home, my cable, my internet, and my
What else?
home security system. My cable.
Do you have any car payments?
Yes, $400 a month.
I thought didn't you say you?
It was repoed and I got it back. So now it's
All right.
$200 bi-weekly that they agreed to give me the vehicle back.
Okay,
My cell phones,
how much?
$200.
Okay,
I pay I actually just got it reduced to $280 monthly for the same case with them, with the criminal side of it, that I have to pay for probation fees, and it's $280. Yeah, $280.
what do you want to say? I'm not going to order people not to pay something I know they can't afford. That's poor judging. I don't want to do that, okay? Tell me what you want to say.
She has a criminal case against her, and she's not even making payments on that. The probation is supposed to be over in August.
Is that,
and that's
hang on, hang on. Is that in front of me or Judge Heston?
Yes. And it's up to date.
Ma'am, listen to me. I hope you listened to the first part that I just stated.
Yes.
I cannot, in good conscience, order people to pay things that they cannot, an amount that they cannot pay. It serves no purpose. Serves none. I've heard enough. I'm going to go ahead and order you. You get paid when next?
The 17th.
Of May.
Yes. Which is next Friday.
Jennifer, you're going to prepare an order that's going to say that defendants to pay $85 bi-weekly commencing May 19th and every other Monday until paid in full. Folks, that's the best I can do. If she doesn't make a payment, and you have to send it to them. Did you hear me?
Okay, because I was bringing them here and they were sending them.
Is that right? We were doing that, Jen?
Judge, because she was indicating there's no contact order, I was allowing her to bring the money order made payable to them, and then I mail
Well,
them.
we're going to allow you to do that, and we'll send the checks to you, but they have to be here in these days.
Your Honor, can I ask for something? So I have to pay the $280 on the 9th, which I have to sign in to see Judge Heston to see if I can get it on my pay period because I had a.
Whatever. What is your question? I'm not. Go ahead. What's your question?
Can we move it out?
Move out and go talk to Judge Heston, tell her what I did. And then you can talk to her about paying your others later there. But I think this has gone on too long. Okay? So no, you're going to have to pay this on the 19th. You got something with Judge Heston? You go talk to Judge Heston. Okay? I don't have any business dealing with her files. Okay? Good luck. 85, I expect you to pay it. If not, you guys file a motion for to set aside the installment payment order. Listen to me. Then they're going to be garnishing wages. And if you think you got financial problems by paying $85 bi-weekly, wait till you see what kind of problems you're going to have when they start doing that. You fully understand me?
Yes, I'm losing everything right now because of this whole case. Yes.
That's a heck of a comment to make.
Run on check to check.
Ma'am?
I didn't ask to be sick and have a blood transfusion.
Well, I didn't want you to have that either, but
for 6 months.
But you owe them money. Had you conducted yourself as you were supposed to, you wouldn't owe them money.
Can I ask you a question?
No. I don't want to get agitated when people ask me questions like that or make statements like that. It'd be like if I didn't pay my credit card company and they started coming after me. And then I stood before a judge and said, boy, this is ruining my life. Maybe, just maybe, I should have thought about not spending so much when I was building up a $30,000 credit card bill. I have nothing more to say on this. I've been more than fair with you. I'm sorry you're going through health problems, but you have to bear some responsibility here. And honestly, this isn't a criminal case, so I don't really care, other than the fact that these people deserve to get their money. You make a lot of excuses and rationalizations. That's all I'm going to tell you. This has been ridiculous how many times you've been here on this. I don't want to say another word about it. If you have a legitimate question besides asking me to do something else, I don't know what to tell you. What is your other question?
I'm not trying to avoid this. I've had people counsel me and tell me, listen, you need to file bankruptcy.
Well, do it then. I don't have any.
But I'm trying to give them.
Ma'am, you gave them $150 in 1 year. Now, did you pay him $150 a month since I ordered the judgment?
From September. That judgment was ordered in September. Okay. And I paid in October, all the way through October.
And you haven't paid November, December, January, February, March, or April. Okay, so if you pay $150 every 6 months, just if you want to quarrel about this, if you got a judgment for over $5,300, that means at that rate it would take 18 years. Now, please don't argue with me. I don't want to hear it anymore. This has been a painful experience on something that should have not taken more than 5 minutes. That's it. Good luck. Thank you.
Okay, just waiting for the parties to come back on number 2.
Hello.
Okay, hold on, Mr. Davis.
Oh, yes, ma'am. Should I go back to the...
Hold on just a second, sir.
Oh, sorry.
Miss Nicker, you want to go in and see if you can help Miss Pena get out?
Yes, Your Honor.
Okay, Miss Pena is coming back. Mr. Davis, if you'll tilt your device there so I can see you. Okay, very good. I've got both Mom and Dad back on number 2. Mom, Dad, if you both would raise your right hand. Do you swear or affirm the testimony you give will be the truth, the whole truth, and nothing but the truth?
Yes.
Yes.
Thank you both. You put your hands down. Okay, Miss Neckar, where are we on this one?
Your Honor, the state's here on a petition to establish petition to affecting the parent-child relationship. After speaking with both parties, it is my understanding Mr. Davis is requesting a reset to hire counsel in this matter. He has had the requisite 45 days notice of this hearing. The state is not opposed to a reset, Your Honor. But if the, court is inclined to go forward, the state would, request to at least do temporary order in this matter. And it's my understanding Ms. Pena is not in agreement to a reset.
So, Mr. Davis, can you tell me? It looks like you were served and then filed an answer both back in December. So tell me what it is you're seeking today.
Well, I've been giving her $400 a month and paying all the babysitting and the groceries and snacks for the boys. I've been given the total of $600 a month, and I have it all documented. And I've been doing that since April 18th of last year. And I've been keeping the boys Monday through Wednesday and every other Sunday. So I've been keeping them 50-50. And
Okay.
I really haven't been court-ordered to pay or anything, and I've been doing all that.
Okay.
And the original court wanted $525, and I've been doing more than that. So I thought maybe somewhere around that $600 that I've already been given.
So are you seeking a non-standard visitation schedule?
No, I mean, if the court has to set what it has to set, it can do that. We already had a mutual agreement.
But are you asking that you continue with what you say that you've been doing previously on the visitation?
Yeah, that would be nice if I could get that approved by the court because that's what I've been doing.
Okay. Okay. So, Dad, I am going to give you a continuance, but just a short one. Okay.
Yes, ma'am.
Okay. So, Mom, Dad, we're going to come back. Can we do May the 19th by Zoom?
My situation is he's going to refuse to pay for the kids, but then still.
Miss Pena, can you do May the 19th at 10?
Yes, this is.
Mr. Davis, would that work for you?
Yes, ma'am. Should I have my lawyer by then?
Okay, so May the 19th at 10, we're going to come back by Zoom. The Attorney General's office will send you a notice. It'll have a different Zoom code than we have today, okay? So I'd encourage both of you to talk to an attorney. When we come back with or without attorneys, we're going to go forward. You understand?
Yes, ma'am.
And Your Honor,
yes.
The state would ask that you order both parties to bring any and all evidence of anything regarding retroactive support, health insurance, dental insurance, proof, those things.
Yeah, and I've always had insurance on the boys.
Okay, hold on, Dad. Hold on. She didn't ask you a question. Okay, so Mom, Dad, you understand what Ms. Neckar is saying. Anything that you want me to consider, I need everything regarding the health insurance the child has or that you have available, everything regarding child support, current income, anything about any child support or any daycare expenses or anything else that's been paid. I need everybody to bring all their documentation, have it available. In addition, in the notice that Ms. Neckar or someone from the Attorney General's office is going to send you, there's going to be an email address that says all evidence needs to be sent to the court 24 hours prior to the hearing. So any documentation you want me to consider needs to be to the court and to all parties 24 hours prior to the hearing. And the email address for that will be on the notice you get from the AG's office with the Zoom code. Okay?
Yes, ma'am.
Okay, we'll see everybody back May the 19th at 10. Thank you.
We're just waiting for your attorney's audio. And there it is. All right, in jail, your name, please.
Yeah, Venetia Compton.
Ms. Compton, this is a felony file, 251565FY. I'm going to go ahead and read this to you.
Good afternoon. Assistant Public Defender Darius here. I'm here on behalf of Ms. Compton. Agreement. We've reviewed the felony file time. He's asking the matter except for probable cause and prelim. She was screened for court-appointed attorney, and that has been granted.
Okay. And so, ma'am, you will have the public defender as your attorney in this matter for the length of however long the case takes. Your bond here is set in the amount of $10,000 as cash or surety. You already have next court dates. You have probable cause conference on May 15th. You have a preliminary hearing on May 21st. That's in courtroom A in front of Judge Scotchless. You will get copies of those dates and times. You must show up for those dates and times. If you're still incarcerated, corrections will make you available. Mr. Sierra, do you wish to be heard on bond?
I do, Your Honor. Thank you. Speaking with Ms. Compton, she does have a job which will not be held if she is held in custody. Additionally, Your Honor, she's not on probation at this point in time. Given the circumstances, the extremely high bond, we'd ask the court to consider a reduction at this time. I know the court is aware she has a record, but she is in compliance and in communication with their attorney when she is pending criminal cases. Thank you.
Ms. Compton, do you even know how many cases you're already out on bond for?
Yes, I'm
how
aware
many
of everything.
pending cases do you have?
One.
No, ma'am. You have 2 different pending felonies and 2 different pending misdemeanors. And then someone, not me, keeps letting you out on bond, and then you just get arrested and charged with more crimes. So I'm considering raising your bond. We'll leave it at $10,000 cash surety for now.
I mean, that's your choice if that's what you're willing to do for yourself. That has nothing to do with me that you don't do your job correctly.
Leslie Denise Limas versus Diego Armando Sepulveda Palomares, cause number 2024 FLA 1469C3. Court marks Ms. Saldana present in person, Ms. Limas present in person, and Mr. Diego Sepulveda present in person. He requires Spanish language interpretation. Ms. Saldana, what is the announcement?
Well, Your Honor, I'm present on that one.
Mr. Schomburg, The court martial present participating by video conference on behalf of the Attorney General's office. Ms. Alania, what is the announcement?
There's no agreement. The parties need a hearing. They're asking if we could finalize the divorce today.
I have about 20 minutes. Can you prove it up in 20 minutes?
No.
All right. Ms. Flores, these are only temporary orders. Yeah, you can come back for your final hearing on July the 8th at 2, which is your final pretrial hearing, or on July the 24th at 2 for your final hearing.
I think the parties both want to go ahead and try to speed it, like get a divorce as soon as possible. So I believe they both would like July 8th.
All right.
But correct me if I'm wrong.
Well, I tell you what, just give me a note. So we're going to leave it on for final pretrial on July the 8th, final hearing on July 24th. Give me another temporary order setting, Ms. Flores, before July the 8th.
Before July the 8th, Your Honor?
Yes, please.
June 9th at 2 p.m.
Temporary orders on June the 9th at 2 p.m. Yeah, any questions, Ms. Alania?
Your Honor, just will the scheduling order continue by alternating the weeks of possession? Because right now we had a scheduling order where father and mother would alternate the child, possession of the child. I'm just asking if that would continue until the June 9th setting.
Ms. Limas, the request is for the current schedule to continue. First question. Do you have any objection to the court ordering that?
Yes, Your Honor.
Let me ask you this question. Have you and Mr. Sepulveda followed that schedule?
Not completely, Your Honor.
Why not?
Because on the first exchange on April 27, when he was going to give me my child, on the morality clause, he broke that. He took his girlfriend with him to exchange the baby, which that's on the court order for him, not like neither him or me have our significant others present while
Is that in the court order, Ms. Alania?
It is, but they have broken up. She's not in the picture any longer. I don't even know that that's true because I know that they broke up, I believe, in
But
that same day.
normally morality clauses are for overnight visits. Was the court more specific in saying no interaction?
It was that the children should not be with the partner or that the partner should not sleep at the home. However, they broke up.
Mr. Sepulveda, raise your right hand. Do you solemnly swear or affirm that the testimony you will give in this case will be the truth, so help you God? Do you swear that the testimony you will give in this case will be the truth, so help you God?
Yes.
You may lower your hand. Is your true and correct name Diego Armando Sepulveda Palomares?
Su nombre correcto es Diego Armando Sepúlveda Palomares? Yes, sir.
Sir, remember you being here at the last hearing and you were here with a female. Is my recollection correct?
Recuerdo que la vez pasada que estaba aquí, estaba usted con una persona del sexo masculino, ¿es correcto?
Así es.
Yes, sir.
And you were romantically involved with that person?
Yeah, she's my girlfriend.
Your lawyer says that she is no longer, you're no longer romantically involved with her. Is that true or not true?
No longer.
Does that relieve your concerns, Ms. Limas?
Your Honor, that is not true. Your Honor, I am concerned about my
But
daughter's.
he's under oath.
Okay.
If he lied to the court, he's looking at jail time. I mean, I can't help him there.
He's still in, I mean, as per his status, he's in a relationship. He has pictures with his girlfriend.
His status, like on social media?
Like his relationship status is he has a significant other.
Do you think the court should take us through everything on social media?
Pictures are proof. I think.
How recent are the pictures?
Saturday.
What's today?
Tuesday.
That can happen. So tell the court what is your concern?
Okay. My main concern is my daughter's current whereabouts. as Mr. Sepulveda was attempting to find a babysitter yesterday through via social media, especially Facebook.
Your Honor, if she doesn't have any evidence
I
to
do.
corroborate that she's filed into case line, I'm gonna object to anything not filed into case
So
line.
let me ask you this, Ms. Limas. Tell the court what objection you have with the court extending what's already been ordered.
That he can care for her.
Tell me how.
I feel it's unsafe for him to hire someone via social media. If I'm okay
Again,
if
I'm
he
gonna object
sees
to
Let me,
that.
let me overrule. You can talk to me and tell the court what is your concern.
childcare. I'm okay with him taking our child to either he can choose and pay his childcare provider.
How old is this child?
She's 2 years old. She's nonverbal yet.
There's
Why does the court, let me ask you this, and then I'll ask you the same question, Ms. Alania. Why doesn't the court just do a right of first refusal?
That was considered, but then the court just said that the parents can take the child to daycare. My client has been taking.
Because
the
you're in
child to
school, I remember this. You're in school.
Yes, Your Honor.
So if you can do daycare, and remember this, if you can do daycare, why can't Mr. Sepulveda?
Okay, I mean, he can do a babysitter, but I do want to request certification on who is caring for my child. Has to be somebody certified to care for her, not just any babysitter. He has no relatives here and no known people. And it worries me that he was searching for a child care through
Again,
Facebook.
Objection to
So,
that allegation that has not been corroborated by any documentation. That has been properly filed into case line.
okay, I'm sorry.
What, Ms. Limas, what, are childcare specialists certified in the state of Texas?
The centers are.
Ms. Alania, does Mr. Sepulveda have any blood relatives in Webb County?
As far as blood relatives, I'm not aware. I did ask him about where the child was, and he stated that the child was with a daycare, at a daycare facility. But I don't know about blood
Well, so
relatives.
look, Ms. Raise your right hand. You solemnly swear or affirm that the testimony you will give in this cause will be the truth, so help you God?
Yes, Your Honor.
You may lower your hand. Is your true and correct name Leslie Denise Limas?
Yes, Your Honor.
Ms. Limas, I recall that when you attend school, you leave your daughter at childcare,
Yes, Your Honor.
and you believe that they're certified?
Yes, Your Honor.
And you want the same thing for Mr. Sepulveda to do?
Yes, Your Honor.
Any objection to that?
Yes, Your Honor, because she hasn't proven that they are actually certified. She's just alleging that they're certified.
Well, I guess what the court is hinging on here is what's good for one is good for all. I mean, alternatively, the court could do a right of first refusal, and I guess I should. But if one party is doing it, then the same standard should apply to all, and at least until we get to a final hearing. I think that is in your daughter's, but yes.
Your Honor, I'm okay with the visitations. I do want to request for my child to be taken to the same child care place. He's not paying for it. He does not have to pay for it. There are certain hours.
He can use that same place at no cost to him?
Yes, he can.
Any objection?
I would need to ask my client.
She just stating it right now. She's just telling me today, because today she just told me the name of the daycare.
Mr. Sepulveda, she's offering that your child be taken care of at the same place at no cost to you. Do you have any objection? So
No, I'm okay.
ordered. These orders are extended. Child visitation schedule, childcare will be at the same place. These orders are extended until July 24th at 2 p.m. when we'll come back for a final hearing. Final pretrial is scheduled for July the 8th at 2 p.m. Ms. Limas, do you have any questions for the court?
Yes, Your Honor. I do want to know what are our schedulings moving forward. Like what days are his and mine?
You're going to put that in writing and extend it out until July 24th, Ms. Aldana?
Yes, Your Honor.
All right. Does the court have Ms. Lima's email address?
Yes, Your Honor, with this hearing on June the 9th for the temporary orders, is that gonna be an in-person hearing?
You can cancel that. I've already taken care of that request. Coming back on July the 8th at 2 p.m. for final pretrial and final hearing on July 24th at 2.
Would this be in person, Your Honor?
Yes, both of you ordered in person on both days. Ms. Lima, do you have any other questions for the court? Mr. Sepulveda, do you have any questions?
No, everything's good.
Any questions, Ms. Alania, or anything else?
No, Your Honor. No,
Anything else, Ms.
No questions, Your Honor. Thank you.
I wish you both all the best. Good luck.
So on the first video, the way the attorney said that dad went and picked his daughter up like he's never been allowed to. Well, now he wants to be a dad. And it sounds like maybe these grandparents helped his ex keep his daughter away from him. And he's not too happy about that. And now he holds the cards. And they have to ask him permission. So, it sounds like he's wanted to step up all along. That's just the impression I get. Maybe not, but that's just the impression I get. Now, the second one with Judge McNally, this woman has a debt and she obviously doesn't want to pay it. She's just not going to. She's paid $150 in the past 2 years or something, at least the past year. Hello, you make $71,000 a year and you can't scrape up a few more dollars? I mean, I know that's not a huge amount, but come on. You could scrape up a few more dollars to pay this debt back, and then it's off your plate. You don't have to do it anymore at all. And it doesn't ruin your credit. So I say pay it back. Now, the Judge Dukes video, I just put that in just to kind of show you, some stuff that goes on behind the scenes. And the way Judge Dukes, she just ignores the questions that she's not asking. When she asks a question, she wants an answer. She doesn't want you to start asking her a bunch of questions. She just wants the answer. And she will continue to ask the question until you answer it. And then she'll move on to whatever she needs to do next. You'll be lucky if you get to say what you need to say or what you want to say. That's why you need an attorney. And then the last one with Judge Villarreal, this is a part 2 of the video I did a couple weeks ago where the mom was holding the child the entire time through the hearing. And then at the end of the hearing, dad got custody because she's been withholding. So we'll see how this goes. I'm going to keep watching that one, but I thought I'd put that in just because it was part 2. So thank you guys so much for watching, and I will see you next time.